Hi, this is Richard Chamberlain. I'm one of the attorneys here at the Legacy Law Group in Perrysburg, Ohio, and welcome back to the Protecting Your Family's Future podcast. Today we're doing episode number 42, and we're continuing in our series on the probate process in Ohio, how it works. Today we're going to be looking at the three types of probate proceedings that are available to us as we take an estate through probate. So the first one we want to talk about is the typical probate. We call it a full probate administration. It's what people typically think of when they think about probate. It is where you have to identify all of the heirs and identify all of the assets and inventory everything and pay all the bills and do the accounting and do the distributions. It takes 6 months to a year to go through. We're going to be talking about that in a lot more detail next week. But that is, as I say, a full probate, and that's the first type of probate proceeding. Then we have the two exceptions to a full probate. If you have an estate that meets these particular qualifications, then you meet the ability to do what's called an abbreviated proceeding. The first of these is called a summary release from administration. It's generally available for a very small estate, usually an estate that has $5,000 or less in it. And it has to do with the paying back of a person who has paid or is obligated to pay the funeral and burial expenses of the decedent. So if you have an estate with less than $5,000 or less than the amount of the funeral and burial expenses, then a person could qualify for a summary release. But the estate can't be more than $5,000. If you have $7,000 of funeral and burial expenses and $6,000 of assets, you can't do the summary release because it's sure the assets are less than the funeral and burial expenses, but it's also more than $5,000, so you don't qualify. So a little bit complicated, but very small estates, $5,000 or less. The other type of abbreviated proceeding is called a release from administration, or sometimes called a relief from administration, or a relieving. That's available for assets less than the typical estate, but more than a summary release. If the surviving spouse is the person entitled to the assets, then it's $100,000. Can be the maximum amount that is allowed to go through the relieving process. If we have a non-spouse as the person or people who are entitled to receive the assets, then it's $35,000 of assets. So in that in the relief from administration process, it's much quicker, typically a couple of weeks to a month or so of filing papers and getting the orders to release the assets to the people who are entitled to it. So obviously, if you have a much smaller estate, you can get through the probate process a lot more quickly, a lot easier. If you don't, then you're into the full probate process. So come back next week. We'll talk about the process for a full probate and what's involved in that. I hope that's been helpful for you today, and we'll see you next week. Thanks.